Welcome, folks. Rambam. We continue with the laws of oaths. Oops. Chapter 10. Okay. If both or one of the plaintiffs witnesses, so we're talking here about witnesses, right, was unacceptable, a relative, or even one of those disqualified from testimony by rabbinic decree, the king, who is not fit to give testimony, was one of his witnesses, or the witnesses heard the testimony from another witness, so not really a witness, they're a witness of a witness. Although they both denied knowing testimony and they took an oath, they are not liable for a shvus ha'edus. For had they testified, they would not have been obligated to the defendant to pay. So we're talking about individuals. The law over here is we're talking about oaths. Oath of a witness means a witness, a plaintiff comes to court and says, I have a witness, John Doe. Not John Doe. No, not John Doe. Reuven. I have Reuven and Shimon, right? But if Reuven was the plaintiff's uncle, he can't be a witness because he's not a kosher witness because he's a relative, right? He's a relative. So he's not a kosher witness. So if he took a testimony and said, I don't know what you're talking about, I have no testimony to give, that's called an oath of a witness, right? Because he wants to absolve himself. Because the Torah tells us if you have to, that you can bear testimony on something, you must bear the testimony, right? So and if the plaintiff comes and says, well, Reuven, right, he can bear testimony to the fact that John Doe owes me, $1,000. But Reuven says, I don't know what you're talking about. He takes an oath that he doesn't know what he's talking about to absolve himself. Afterwards, he was found to be a liar. Oh, because of that, he has to bring, if it was accidental, inadvertent, then he has to bring a sacrifice. Otherwise, he's liable flashes. Right? Now, that's what we learned before. Now, because he's his uncle, what would have happened if he would have given testimony as a witness? It would have been thrown out of court. Why? Because he's not a kosher witness, because he's a relative, because he's a relative, because he's a relative. Not because he's not an upstanding person, because he's a relative. He's a relative.
It's not what you're saying.
Yeah, can't bear testimony. So now, but he took the oath saying that I don't know anything. Is he now liable? No, because his testimony would have never obliged the defendant to pay because it would have been thrown out. So therefore, he wasn't proper witness to begin with. So therefore, his oath of witness that he is denying that I know anything means nothing. It's null and void. In other words, his testimony had to be in a position that he would have obliged the defendant to pay. But since he wouldn't have, so then it's not called a oath of witness. Okay. If the plaintiff said, I'm administering an oath to you that you come and testify on my behalf that so-and-so promised me to give me 200 zuz, but he did not, and the witness is denied knowledge of the matter, and took an oath, they're not liable for Ashvus Eidos. Why? Remember, they took the oath and they were lying in the end. That's what we're talking about. Obviously, if they weren't lying, then it's finished. The laws here about that they took an oath and they lied about what their oath was. So here we're saying, anyways, that's not a Shavuos Eidos. Even if they would testify concerning the matter, the defendant would not be liable financially because of its statement. Similar laws apply to an analogous situation. Because what is the plaintiff saying? I want you to take an oath because Reuven promised to give me 200 zuz. Even if he did promise, let's say he did promise, right? And now you have witness to say they promise. Is he obliged? The promise isn't an obligation, right? So therefore, he would never, even with his testimony, oblige him to give. So therefore, that's not called an oath of witness. Is that clear? If one charged witnesses with testifying that he was a Kayin or a Levite, or that he was not the son of a woman who underwent a divorce for Chalitza, and the witness denied knowledge of the matter and took an oath, they are not liable for Ha'edus, for this is not a financial claim. So someone knows testimony to say that he's a Kayin, right? You need testimony to prove that you're a Kayin in order that you could do service in the Holy Temple, right? You need testimony. Your own claim is not sufficient. We learned that earlier. So this guy now said, well, I don't know what you're talking about. And it was a lie. But since there's no financial claim over here, therefore it's not called Shvus Eidos. Shvus Eidos means that my testimony, if I were to give the testimony, I would oblige the defendant to make some kind of payment. There would be some kind of financial benefit to the plaintiff. But here it's not financial. It's a spiritual benefit, but not a financial benefit. Therefore, it's not in the category of this. By the way, we're not talking about over here that, a person shouldn't do these things. That's not the point over here. A person shouldn't do this. A person shouldn't, who knows testimony and make a false oath. Right? Obviously, shouldn't do it. That's not the point over here. And that goes without saying you shouldn't do it. Right? It's not honest. But the point over here is under what parameter of law does this fall under? That's the question. So it's not, because over here, if it is a Shvus Eidos, that means either the person has to bring in a sacrifice. Like they made a mistake. Oh, you know what? I didn't realize that I was there when he said, when I didn't realize that whatever, he inadvertently made a mistake. So he would have to bring a sacrifice, because in the end, you took an oath of God's name, right? So you have to bring a sacrifice. Or I just, second. Yeah, you would get lashes if you were, if you did because you took God's name in vain, right? And so in this instance, you wouldn't, because it wouldn't fall in this category. Now, maybe it would still fall in the category. Okay, similarly, although the witnesses denied knowledge of the matter and took an oath, they're not liable for Shvus Eidos if the plaintiff charges them with testifying with regard to the following claims. His son inflicted a wound upon him. So-and-so kindled his grain heap on Shabbos. So-and-so raped or seduced a virgin daughter who had been consecrated. The rationale is that they give the testimony the defendant would be liable for execution by the court and not making financial recompense, as we explained in Hilchas Naira. Similar laws apply in analogous situations. What's happening over here? if you kindle a heap on Shabbos, right? If there were witnesses, right, that warned you, you would be then liable, death sentence, right? Likewise, rape, you're liable a fine. I don't know how the raped one works because there would be a fine. Oh no, he'd have to marry her, I think. No, there's a fine. I'm not certain on that one. In son inflicted on the father a wound. You know what? There's a death sentence for that too, right? Point being, over here, there's no financial payment where there is a possibility of death sentence. Even if there isn't a death sentence, you're not liable it, because you could be liable. There is no financial recompense. Huh?
Comes across to me as though it's the father is responsible.
Huh? Right. Oh, I know, because it's not a financial recompensation. What it is it's not financial, it's a fine. It's a penalty. That's not called financial recompensation. Recompensation is for, I gave you to watch my, my phone, and there's a value to it. And there's a value to it. A penalty is not a value to something. It's just a penalty. So it's not called financial. Penalties are called, even though it's about money, but it's not a financial matter. That's the point. Okay. If there's only one witness who denied knowledge of a financial claim and an oath was administered to him, and he's not liable for shvus eidos, rationale is a testimony of one witness that's not obligated financial payment. Simple, right? Because one witness would not obligate the person. So even though the person then, he lied. Not talking about, obviously, you're not allowed to do this. Can't take God's name in vain and say, I don't know testimony, and say, in the name of God. And when you do know testimony, right? But since his testimony anyways wouldn't obligate, so it's not called shvus eidos because it's not testimony. Testimony that obligates is only with two witnesses. Right? We've learned that in the past. If one charged two witnesses with testifying that his wife committed adultery and denied knowledge of the matter, and they took an oath to the effect, they are liable for shvus eidos. For had they testified, they would have caused her to report the money due to her from the ksuba. So here there's a financial gain for the husband, right? This is about the soita, right? He's got two witnesses that she committed adultery, but she would lose, therefore, the money that would come to her for the marriage contract, the ksuba. So since there is that, and that's financial, that's not a penalty, it's financial. He wouldn't have to pay the ksuba. Means he's gaining money. And they are not giving testimony, and they lied, saying that they don't know. Well, therefore, they fall in the category of shvus eidos. That's the one who charged them with testifying would be freed from liability, and so witnesses have denied a financial claim. Okay. Gonna stop here. It's been a pleasure.
Thank you, Rabbi.
Thank you, Rabbi.
Have a good Shabbos.
Thank you.
Thank
Good
you.
Shabbos.